Hey, Melissa Wick here. I own Wick Law Offices, a small business law firm here in Columbus, Ohio. Today, we're going to talk about breach of contract and common defenses to that claim. If you're ever sued, it's super helpful to have someone in your corner who knows how to bring affirmative defenses. So it's simply not enough just to deny the claims, right? So if someone sues you, they're the plaintiff and they're going to file a complaint against you. And it's not enough just to file an answer saying, I deny this, right? You want to examine any affirmative defenses you can bring so that you have a better shot of getting through this lawsuit unscathed. So when someone brings a claim for breach of contract against you, if they're the plaintiff, it's their obligation to prove that in court, right? It's their case. They have the burden of proof. So they need to show all the elements for breach of contract, and there are four, right? The first element is that there's an actual valid contract that exists, right? Sometimes people think there's a contract and there's not, right? The second thing they need to show is that they, as the plaintiff, performed their duties and obligations under the contract. The third thing they need to show is that you, as the defendant, didn't actually perform your obligations and duties. And the fourth thing they need to show is damages, right? So they need to show that somehow they were harmed, right? They can't just complain about a breach of contract if there were actually no damages. Okay, the first element, was there a valid contract? A good lawyer is going to sit down and take a really detailed examination of the communications you guys had leading up to the contract. So things like emails and text messages all go into sort of everyone's state of mind as they formed a contract, right? So that stuff's all really important. Another thing that they'll want to look at is whether or not there was valid consideration. Consideration is a legal term, and what it is that you've exchanged something of value. You've each exchanged something of value through the contract. And a good lawyer will want to examine, was there a very clear offer? Was there acceptance of that offer? Or was there a counter offer? All those things go into the party's state of mind and how the contract was formed. So super duper important. The next thing a good lawyer is going to want to talk to you about is if there was a breach, right? So you're going to want to be really upfront with your lawyer. If you breached the contract, for whatever reason, you're going to want to tell your lawyer about that. You're going to want to tell your lawyer about the circumstances that led to the breach. And a good lawyer is going to examine whether or not the breach was actually material or not, right? So if you breach just a tiny, teeny little bit, like maybe you went over a deadline like a week or two, that's arguably not a material breach, right? So a good lawyer is going to take a look at whether or not that breach really matters in the scheme of things. The next thing a good lawyer is going to look at is whether or not the plaintiff has actually incurred damages. And I see this a lot. Sometimes people just are mad, right? Sometimes they're angry and they want to sue, but when you look at the damages that they've incurred, they're minimal or they don't exist at all, right? Maybe they're mad because there was a delay because of COVID or material supply issues. And they're upset because maybe, the project wasn't completed on time, right? But at the end of the day, their damages just don't exist, right? Because they haven't really been damaged in any significant way. I mean, you can't just sue someone because you're mad. Okay, if you do get sued though, you're gonna wanna have a lawyer bring affirmative defenses on your behalf. So I'm gonna go through a list of common affirmative defenses. The first one is fails to state a claim upon which relief can be granted. That's just basically listen, your complaint doesn't even really state the basic elements or facts that support the elements of the cause of action. A second common defense is that the claim is barred by equitable defenses such as estoppel or waiver. A third common defense is that the contract itself has problems, that it maybe lacks consideration. A fourth common defense is a statute of frauds problem. A fifth common defense is contributory negligence. A sixth common defense is duress. And the seventh is assumption of the risk. Okay, so I hope you're never sued for breach of contract. If you are, please watch this video and then give me a call immediately. My number is 614-572-6366. My email is mwick@mwicklaw.com. Thanks for watching.